You are now listening to Comp Corner, brought to you by the law offices of Bradford and Barthel.
What is up? I'm your host and favorite defense attorney, Nasser F. Adil. Welcome to Comp Corner, the only podcast where the workers' compensation community gets legal insights, a few laughs, and hardly any telemarketer spam calls. On every episode, we break down claims, chaos, and the unique joys of our industry, all with a smile. Let's get into it. A quick reminder, this episode does apply for CE credit. This episode applies for up to 60 minutes of CE credit. Please see the show notes for information on CE credits. In the show notes, you can find the link to the CE credit form or send an email to compcorner@bradfordbarthel.com. That's compcorner@bradfordbarthel.com for a link to the CE credit. On this episode, we have the honor of being joined by Louis Larres and John Kamin. Louis is the director of our appellate division, and he had the privilege of arguing the Rodriguez case for the defense at the Court of Appeal. John is the director of our firm's editorial board, and of course, John argued the Rodriguez case at the trial level. John, Louis, and I discussed the main takeaways from this published decision, the likelihood of appeal by opposing counsel, what the Patterson Doctrine stood for, how the decision impacts the burden of proving a change in condition, what the decision says about writ denieds, some key dicta from Rodriguez, and the broader impacts and implications on potentially fewer hearings, effects on utilization review, the medical community, and disputes of continuity of care. And of course, on to our guests, John and Louis. A humongous Comp Corner welcome to our guests, Louis Larres and John Kamin. Louis is an equity partner and the director of the appellate division here at Bradford and Barthel. Louis argued the Rodriguez case for the defense at the Second District Court of Appeal. John is also an equity partner and the director of the editorial board with our firm. John argued the case at the trial level. John, of course, is also a returning guest on Comp Corner as he appeared on episode number 6 back in July. Louis and, of course, John, welcome. Thank you both for your time.
Good to be here.
Thank you. Great to be here.
I'm excited to have you both on to discuss Rodriguez, the Patterson Doctrine, and provide your high-level insight on where we currently are. And of course, our audience wants to know, including myself, where we may be headed. So, gentlemen, as we sit here in mid-November 2025, what's the main takeaway from this published decision? Louis?
Well, I think the main takeaway is that there is no longer a continuing care exception to whether or not a defendant or an employer can submit a request for authorization to utilization review. That was kind of the main holding in Patterson. We can get into that a little more later. But in those types of cases where the defendant may have previously authorized treatment by means of UR, they no longer have to prove up a change of circumstances, which was a requirement that, to my knowledge, was almost never a burden of proof, which was almost never sustained by the defendant in a lot of the case law that I've looked at. But that is no longer the requirement or the burden of proof, and the court properly puts the burden of proof, I think, on the injured worker where it belongs, to show that ongoing care is medically necessary.
John, anything you got for us on that? Main takeaways as far as from the published decision?
Louis summed it up really well. But yeah, just to recap, I'd say it definitely eliminates confusion about whether a defendant can send something to UR And it does eliminate that shifting of the burden of proof that Lewis was talking about. So under the old Patterson case law, when the burden of proof was shifted to us defendants, defendants such as myself had to spend more time and clients' money on discovery to try and prove that nebulous change in condition, which was always difficult to prove. So we'd wind up taking more depositions, issuing subpoenas, just doing more discovery, more investigation. Now that we don't have to prove a change in condition in order to send something to UR, that additional layer of discovery, defendants no longer have to do.
Sure, no, that's great. I mean, I think so. This shifted the burden of proof to defendants to prove a quote change in condition, close quote. Some of the difficulties you mentioned, John, I mean, they're hard to ignore here. I mean, those of us who practice, we remember the difficulties, right, with proving a change in condition. You mentioned having to subpoena records, different layers of discovery. What other difficulties were presented before with regards to the prior burden of proof, where we had to be the ones to prove that change in condition?
So, for instance, what types of evidence you could use to prove a change in condition was always. I used the word nebulous earlier because it was never quite clearly defined. And so, for instance, in this case, the Rodriguez case, at trial, I was actually arguing that the comments made by the applicant's own treating physicians constituted a change in condition. And the judge ruled that that was not a change in condition. And what I'm referring to is, in this particular case, the applicant's own occupational therapists and doctors were saying that the applicant was getting too reliant on the home health aide. In other words, he was letting the home health aide do everything, open the mail, read the stuff. And at some point, as patients improve in their condition, in order to improve, they need to do stuff. They need to do activities of daily living. And so when I read that and the treater's reports in the Rodriguez case, I thought that that was a change of condition, and clearly the judge and the appeals board disagreed. But one of the other difficulties that would come up is in another case, I would try and use the QME reports, which were quite different. And I had the trial judge tell me, no, you can't use those because the Sandhagen decision doesn't let QMEs comment on medical treatment disputes. And I disagreed with that because a lot of cases are different than the Sandhagen case. And I won't go into all that right now. But when that judge issued the findings and award, the judge did not mention Sandhagen at all. But the judge did side with the PTP report over the QME reports. So I found it interesting that we would hear different things from different judges about what evidence you could use to prove a change in condition, but it was never clearly defined and therefore never clearly something that could be obtained.
Sure. Now, thank you for that, John. Now, Lewis, of course, there's never any guarantees in law. If anyone says there are guarantees, they're clearly lying, but we can't ever guarantee the future. But do we expect applicants' attorney to appeal?
Yeah. And actually, I just want to kind of jump on some of the things that John mentioned really quickly before I dive into that. But the lack of clear standards, I think, was part of the problem with the system under Patterson. As John highlighted, how was the defendant supposed to prove that? Was it through the QME process? Probably not. Was it by means of the treating physician recommending the treatment, the disputed treatment? Possibly, but if that's your only recourse, I think that also highlights one of the comments I made, I think during oral argument, or at least in our briefing, was that that's a due process issue. How do you obtain rebuttal evidence if the treating physician is your only source of that evidence? So Patterson is problematic for a number of reasons, not least of which is this constitutional due process issue. But to answer your question, I think the short answer is yes. I think given the outcome here and given the stakes, I anticipate applicants' counsel to appeal. They have 40 days to do so. which I think I pegged at about December 21st, I think, based on the date of the decision. So we should know something by then. And of course, the Supreme Court, they get inundated with thousands. I think, and John can maybe chime in on this as well, but I think it's like 7,000 to 10,000 petitions in a year. Wow. And they take maybe 3 to 5% of those cases. There isn't, thankfully, yet a split of opinion on this issue. While this is an important issue, I don't think it's important enough to the community to the effect that it will garner the Supreme Court's attention. So if they do grant review, that will have an impact potentially on the our ability to rely on Rodriguez going forward. But until the court decides the issue, if they take it up. But I think there's, again, if I could read the tea leaves, I probably wouldn't be working in comp. But,
right. None of us would.
I think there's a small chance. I would say a small chance that the court will take it up, given where we are now in terms of the scheme of things.
Yeah, it's a fascinating time. I mean, so much going on, so many different directions. So that's really awesome. Thank you for that, Louis. Now, John, if you can just answer for our audience, is the published decision citable authority at this time?
Yes. So assuming that the state Supreme Court does not grant review, then yes, this is a published decision and is citable authority. And so that's good to know. It's citable in... So it's a decision from the Second District Court of Appeal, which covers Southern California. But because it is a published decision and there is no contradictory published decision out there, this is citable across California. And just to touch on the odds of the state Supreme Court granting review, as a gambling man, I'd say that's less than 3%, personally. And the reason why is if you look at like the number of state Supreme Court cases or decisions on workers' compensation issues over the years, we could count those on two hands in like the last 15 years, right?
Sure.
And one of the reasons why is that they're looking at the entire globe of law out there. So think about all the criminal cases where they have important criminal issues going up to the state Supreme Court. And I think when the justices look at all the stuff going up to them, I think criminal cases are definitely high up on the ladder because that's someone's rights, someone's future, and their freedom. So I think that they tend to give more weight to criminal matters over everything else. And then there's a separate hierarchy a little bit lower. And just one last note on that. If you look at it, probably one of the most controversial and hotly litigated issues in comp is the grant and study practice. Sure. And I personally thought that the state Supreme Court was going to review that in the last year, and I was wrong. So if they aren't looking at something as controversial and hotly debated as that, then I frankly consider Patterson a little lower on the totem pole compared to the grant and study practice debate.
Fair.
And so if grant and study is not being evaluated by the state Supreme Court, I'd be frankly shocked if they were going to look at Patterson before grant and study.
They are still weighing the equitable tolling, though, aren't they, John? Is that case still pending? The Zurich case, I think it is, where we had conflicting opinions from the two district courts, or at least, not two conflicting. We had multiple opinions from the district courts of appeal, one in line with the other, disagreeing with what the WCAB was doing in situations where a recon is filed, but the board doesn't act on it in time within 60 days. And the board was arguing equitable tolling applies. I think that's still pending before the Supreme Court, right?
Well, and so it's very confusing. And the reason why is that there was a batch of cases that they had granted review on at the end of 2024, end of 2024. And then when I circled back in spring of 2025, they were no longer reviewing that. And the reason why is that the underlying cases had settled. So it looked like they were going to review that. Now, I do remember that there may have been a case after spring of 2025. But yeah, so there were a few cases on grant and study which it looked like they were going to review, and then they settled, and suddenly they were off the court's docket. So that's why things are always changing, and it's hard to predict precisely what they're going to review and opine on.
Fair. Well, thank you both for that. So to dig a little deeper here, Patterson, Rodriguez, those are obviously names that are flaunted about quite a bit today in workers' comp, especially this week. Now, Louis, can you please tell us what exactly is the Patterson Doctrine and what does that stand for?
Yeah, so Patterson, just give you a little history here, it's not an in-bank decision. It is a significant panel decision, which means it's slightly better than or more persuasive than your common everyday panel decision that the WCAB issues. But again, it's not an in-bank decision, so it wasn't necessarily binding on the trial judges across the state. But it's a 2014 decision, and for 11 years, I've been, for John and I and other defense attorneys have been banging our heads against the wall, trying to argue against this, the application of Patterson. And so essentially what Patterson says is that if there is or once the defendant authorizes medical treatment, that treatment must go on in perpetuity until the defendant can show a change of circumstances. And in essence, and this is kind of what the board argued in Rodriguez, is that you don't get to the UR-IMR process because there is no need for an RFA in those continuing care or ongoing care situations. And if there's no need for an RFA, which is the triggering document for the UR-IMR process, you completely undercut or do an end run around that process, which is supposed to be mandatory. And that's, we'll touch on that later, but I think that was the main thrust of our argument on appeal in Rodriguez. And that was the main thrust of the court's opinion, and why Patterson was inapplicable and wrongly decided. But that was the law of the land for 11 years. And the only cases where the board found an exception to Patterson kind of across the board was situations where the disputed medical treatment involved medication. And the board seemed to recognize that was an exception because medication usage is, in most cases, time specific or prescribed in discrete, quantifiable units of time. Sure. And in those cases, the board found an exception, which is what we tried to argue. I know John has, and I tried to argue multiple times that in cases of home health care or in-home support services, anything like that, residential treatment facilities, those were oftentimes requested in discrete blocks of time. But the board, for whatever reason, was very bent on allowing that treatment to continue despite that similar fact pattern.
I know, Louis, you already did elaborate on it a little bit, but John, in your opinion, how was the Patterson Doctrine influencing defendants' decisions to authorize care instead of sending it to UR?
And unfortunately, that's a very simple answer, I should say.
Right.
And the simple answer is that with the Patterson case in mind and the appeals board eagerly applying it, I would have to advise my adjusters not to authorize anything and to send everything to UR. And that kind of is a backwards type of logic. And the reason why is that defendants should not have to fear authorizing something out of the fear of being punished forever for authorizing that one thing, whether it's home health care or medication or physical therapy.
Sure.
Just because the adjuster, was persuaded, hey, I think this is a good idea. Yeah, the applicant could use that. Sure, I'll press the authorize button and send out that nice letter, and they can go get their 12 physical therapy visits. Well, no, adjuster, you just agreed to provide physical therapy forever.
For perpetuity, right?
Yeah, for perpetuity. And so really, we would have to advise the adjusters, even though you may have a certain feeling one way or the other about it, you have to send it to UR. And the adjusters would agree, because as I talked to more adjusters about this over the years, most adjusters had been burned by authorizing something and then being punished forever for authorizing that one thing. And so I felt that wasn't right. And it's frankly not in the best interest of injured workers.
Right. No. And Louis, anything you want to add on that, please?
Yeah, if I can. The problem I had with that is that it seems to be a run afoul of Labor Code Section 4909, which is essentially that the provision of benefits, or 4903, I should say, the provision of benefits is not an admission of liability. And that was one of the arguments we raised in numerous cases, including Rodriguez. Unfortunately, it didn't get any traction with the Court of Appeal, and I'm fine with that because they gave us what we wanted. But but that still doesn't sit well with me, at least in terms of how the court had applied Patterson. They never addressed that issue head on, but I think it completely runs afoul of 4903 to simply stick the employer with the obligation to provide treatment simply because they had authorized it previously and deny them the right to seek periodic review of that treatment.
Sure. And that's what makes this whole decision a real game changer of sort, right? It really changes the way claims are handled. The treatment authorizations are less likely just to have to get authorized. I mean, in comp, I'd say we get game changing cases every 2-3 years. And I think this absolutely is one of them. Now, John, in your opinion, could this decision result in fewer expedited hearings and possibly, dare I say, alleviate the court calendar?
Yes, I think it could. And for instance, the Van Nuys Workers' Compensation Appeals Board right now has a really flooded docket.
Sure.
And I'd say they have a number of expedited hearings which are set on Patterson issues. And I think the same can be said for other Southern California boards. With me being based in Southern California, perhaps you gentlemen could speak to Northern California, but I do know in LA and Van Nuys, for example, there's a good number of expedited hearings. And expedited hearings are not like status conferences for those who haven't attended one. Those are like mini trials, and they can take up as much time as a trial. They can take up multiple days. You may be continued to another trial date from an expedited hearing. And so by removing expedited hearings on that from the calendar, each one that's removed could be construed as the removal of 1 to 4 calendar dates or 1 to 4 hearings for that case. So if you multiply that times 100 cases, so let's say you had 100 expedited hearings calendared over the next 3 months at the Van Nuys board, and those are now neutralized by this decision, that could be as many as 400 potential hearings coming off that board's calendar in the next 9 to 12 months. So that's quite a few.
Yeah. And that's only a one board. Think about across the state, right? That's going to be thousands, potentially thousands. I mean, that's just going to clear the docket and really make a big change. I think about 7 or 8 years ago, there was a change in the panel rules where no longer were the panel requests mailed in. They ended up being online. And at the time, a lot of us looked at each other like, what is the state doing here? But gosh, that really, really severely reduced the amount of cases that had to go unexpedited. The court was freed up to do actual work instead of having to hear panel disputes. I think hopefully the same with this. We can have more time for the court to actually hear cases that need to be tried rather than continuances or OTOCs for unnecessary reasons. Now, in the attorney community and claims community, I think we all know kind of the impact that this has as far as Rodriguez. Louis, in your opinion, what's the impact on the medical community? How is that going to possibly change things up?
Well, yeah. So during the course of this litigation, and as I thought about what crafty doctors might do if Patterson were upheld, I think a doctor could simply withhold ever issuing an RFA. If the RFA is the triggering document, then a doctor could potentially withhold issuing an RFA if he has a prior authorization. Why is there a need to submit RFAs going forward? So I think the impact on the medical community at this point is maybe twofold. One, the need to issue an RFA at regular intervals, and then two, to really delve into the treatment guidelines to justify either an exception to that interval that is specified in the treatment guidelines, or to justify the ongoing treatment itself for another periodic interval. So whether that'll come to fruition, I think, is a whole nother matter. But I think we now have, and we being the defense community, I think has another arrow in its quiver in terms of holding doctors to be more accountable when it comes to treatment.
Fingers crossed, right? That's the whole goal. I think John, who does a great job with the editorial board, he came out with a blog recently post Rodriguez. And like John, you talked about previously, treating physicians in our community oftentimes had little/no incentive to provide a change or improvement in the patient's condition. Can you elaborate a little bit on that and talk about how hopefully the workers' comp system can hopefully be changed for the better?
Yes. So you make a good point. The PTPs in these Patterson issue cases really had no financial incentive to ever change their recommendations for the costly medical treatment that they were recommending.
Right.
And sometimes they were recommending this at the urging of the applicant's attorneys. And so there is that implied threat of if they don't recommend what the applicant's attorney is asking them to recommend, then that applicant's attorney may choose a different PTP in the future.
Right.
And so then that leads to the old axiom that we were laughing about the other day, that the workers' compensation system is the only medical system where the patients never seem to get better.
I love that. Love that.
Yeah. And so that's, I think we've all heard that in court over the last 3 or 4 decades. And unfortunately, it's true. A lot of these treating physicians never want the applicant to get better. The medical treatment always has to be the same as the first 6 months after their date of injury. And that just doesn't make sense. That's not how medicine is practiced. And so to touch on Lewis's point that he was just making, this does kind of return the power to utilization review, which is codified in statute. So it's not like it's some frivolous thing. And the reason why Senate Bill 899 and subsequent legislation was passed was to go back to evidence-based medicine. Yeah. And that's treatment guidelines, which are the result of thousands and tens of thousands of studies and medical research. And one last point I'd like to make, these UR decisions are not written by defense doctors.
Right.
For instance, I see doctors' names writing UR denials, and I'm not going to say a name, but let's say it's Dr. X, and I were to propose Dr. X as an AME to my local applicant's attorney, they would be overjoyed that, John, thank you for proposing Dr. X. Oh, yeah, we'd love to have him on our case.
Right.
So that's who's writing these UR denials. It's not just defense doctors or just middle-of-the-road doctors, but it's also lien treaters and applicant doctors, doctors who we would call applicant advocates. And so I think it really does return the power back to evidence-based medicine, and that's what lawmakers intended in the first place.
For sure. And I think that's the joke is that a lot of PTPs out there, they don't know how to write impairment reports because they don't know the AMA guides. But we hope now the PTPs can actually change from designating the word TD all the time to maybe providing some work restrictions and thinking outside that box. But we hope that it does provide a change or improvement in not only the applicant's condition, but also in the change in the system. So thank you both for that.
Have you ever had the pleasure of reading one or more of the hundreds of newsletter articles found in the B&B blog? If not, you are missing out on a tremendous tool. Every week, our attorneys demonstrate their special insights into the defense of workers' compensation matters. Individual articles are available on our B&B blog page at bradfordbarthel.com, where you can also sign up to automatically receive new articles and upcoming webinar information.
Now, during the oral argument at the Second District Court of Appeal, Lewis made a point about how the UR/IMR process serves the art of medicine. Lewis, could you elaborate for our audience what you meant by that?
Yeah, that was kind of part of my argument that it tied in with or dovetailed with the legislative intent,
right,
which was, of course, to put the decision-making power exclusively in the hands of medical experts relying on and who are trained in using evidence-based medicine. And the art of medicine, really, I think, is that every case is different. No patient is identical to another patient. And you've got to look at the symptoms, their progress, their lack of progress, how they present, the objective criteria, to really formulate a treatment plan and to assess and reassess. That's the whole scientific method, right?
Sure.
So my point in arguing that was that, and in fact, I think I led off with this to comment that after hearing the questioning from the court and some of the arguments from the respondents, was that all demonstrated precisely why the legislature in its wisdom put medical decision making in the hands of those who should be making that determination, which is medical
Sure.
experts, not judges, not attorneys. And so the art of medicine, I think, encapsulates that medical decision-making process, that every doctor should look at every patient as an individual and then assess whether there are exceptions to the guidelines or whether the guidelines apply, and in making future medical recommendations.
No, excellent. Thanks for that elaboration, Lewis. Now, what, in your opinion, what did the decision say about writ denieds? As far as what do you believe our audience could learn from, as far as what came from the decision?
There's actually two sort of non-medical related aspects to the Rodriguez decision that I think bear some comment. The first is in footnote 3, which deals with the interesting kind of aside that the court makes, that there is the board and the parties and the record itself in this case offer no explanation as to why the board took 5 years to decide this case ultimately. And that's kind of an interesting aside too, because the one of the hiccups in this case was that the court initially, while I was on vacation, denied, or actually didn't deny, they dismissed our writ, saying that it was untimely because it wasn't filed in the 45 days from the date the WCAB's decision was deemed final. And they were arguing, or they were under the impression that because running from the date that the trial decision issued to the point that the recon was filed, or deemed filed, I should say, that time was longer than the statutory 25 days. And so therefore our recon was, or not the recon, sorry, that our writ was untimely and should have been filed 5 years ago, basically, is what they were implying. And so we had to, both us and the WCAB wrote to the court saying, no, this is why the WCAB did what it did in terms of getting to the actual merits of the decision, and why they deemed the recon filed when it was filed, because of the whole shutdown during COVID. This was, you go back 5 years, this is right in the heart of March 2020 during the shutdown due to COVID. And so the recon wasn't deemed filed until so many months after. I think it was 2 months after we'd actually filed it. And so the court looked at that timeline and said that our writ was untimely. And so it took a letter from the WCAB, and I filed a petition for review with the Supreme Court saying, no, this should be remanded back to the Court of Appeal. And thankfully, the court took it up and addressed the merits of the appeal. But the footnote there is interesting because there is no explanation in the record as to why it took 5 years, and that goes to what John was talking about earlier. This whole the problem that's created by the board's review or grant for further study process is that once the court or once the WCAB grants review, there are no time constraints on the board in finally getting to a decision. And I've had cases linger up there 2-3 years waiting for a final decision on the merits. And this one is one of those extreme ones where it took 5 years approximately for the board to finally issue a decision on the merits. So that's one aside or one non-medical sort of tangent that comes from this decision. The other one is the writ denied thing or issue, and the one thing I'll say about that before turning it over to John is the board was citing to cases and almost like boilerplate that, because I've seen them cite that or use that exact same language in other decisions of theirs, where they will imply that the decision is the will of the Court of Appeal when it's a writ denied case, which of course means that the Court of Appeal didn't address the merits. And so the court we picked up on that and I raised that as an issue in the writ, and the court devoted some amount of their decision to the board's reliance and the phraseology, if you will, of how they cite to those cases.
Great stuff, Louis. Thank you for that. John, anything that you have as far as writ denied, or anything you believe that the decision says that you think our audience could learn from?
Yes. So from my background of first covering the appeals board as a journalist for years and the legal editor at WorkComp Central, workers' comp, we often operate in this unclear field of case law where people are citing panel decisions, but those are not controlling authority.
Right. And
people like talking about panel decisions like they are controlling authority. And we only have so many unbanked decisions, which I get. It's hard for all of the commissioners to all rule on one case at a time, especially when they have thousands of petitions for recon before them. So I totally get it. It's not practical to expect the appeals board to be issuing en-banc decisions, which are the only source of controlling authority from the appeals board year after year after year. They can only do that so many times, and it's not practical to expect them to do that. So when cases would get decided by a panel of 3 commissioners, and then a party would recon them, usually a defendant, and then the District Court of Appeal would deny review, that's how you get this writ denied situation. And so for years, some of the publications have been citing writ denieds as having a little more value than your average panel decision or some of the other decisions out there. And here the appeals board, like Louis was saying, they cited 2 cases which were denied by the District Court of Appeal. So in other words, there was a recon just decided by a panel of appeals board commissioners, and then it goes up to the Court of Appeal. And so when the appeals board was briefing this issue at the second district, they cited these two writ denied cases. And the second DCA said, whoa. And here's their exact language. A summary denial of a petition for judicial review of an appeals board ruling decides no issues and has no precedential value. And they go on to clarify, and this is their language, not mine. The appeals board incorrectly characterized a case summary of Rivota, that's the name of one of the cases, as a decision of this appellate court upholding the appeals board application of Patterson. And the appellate court goes on to say, no appellate court has adopted the appeals board reasoning in Patterson, and we decline to do so here. So I think what it does is it really undermines that popular opinion out there that writ denied somehow carry a little more value than some of the other persuasive authority. And here, this is the Second District Court of Appeals saying, no, they don't.
Right. That they put it out there, that's for sure. Now, whenever a case like this comes down, it's not just the case itself, right? It's always the impact and the implications from the case. Now, when it comes from just as far as disputes on continuity of care, what impact do you all believe this will have on disputes of continuity of care?
Well, I think you may see some interruptions, especially if the doctor fails to, the primary treating physician or the recommending physician fails to justify that ongoing care sufficiently under the treatment guidelines to support that recommendation. And if that's the case, then you run the risk of saying, this is no longer necessary, or there's no justification for it on the treatment guidelines. There may be a lot more IMRs then as a result. And then some of those may, the IMR does overturn some UR decisions, some UR denials. So there is a possibility for an increase in IMR applications, perhaps.
Now, as far as broader implications, as no one can make guarantees, of course, we know that, but what are some of the broader implications? I mean, we've heard things, some people say, hey, you guys already mentioned Dubon. I'm not trying to say it's up for grabs, but what are some of the broader implications you see as far as the next steps that could be an effect in workers' comp because of everything that came down as far as Rodriguez and the different opinions of the Patterson doctrine?
Well, assuming Rodriguez stands, which I hope it does, of course, I think that opens the door potentially to revisit the board's analysis in Dubon, because the court in Rodriguez has very strictly construed the statutory or the legislative intent behind the statutory scheme, this UR-IMR process. And they make it very clear that is the only dispute resolution process. So for those listening, just to refresh your recollection, Dubon is the case that says that the board has jurisdiction to decide treatment when the UR is untimely. And I think, again, given the language in Rodriguez, that's up for grabs, or at least up for some debate. If UR is untimely, the board has jurisdiction to decide timeliness, but then I don't think, or at least I think an argument can be made under Rodriguez that the board still in that situation does not have jurisdiction to decide medical treatment.
John, anything that you think broader implication wise, do you think that anything's up for grabs or can be a bigger change in the grand scheme of workers' comp?
Yes, so I can actually take it outside of Patterson and Rodriguez and apply it to something completely different. So about a month ago, the Fourth District Court of Appeal issued a decision on jurisdiction on a sports claim. And they said that the appeals board does not have jurisdiction over a sports claim. And in essence, what that decision, that's the Wayne Gandy decision from the Fourth District Court of Appeal, the Fourth District had ruled that the appeals board had found jurisdiction and that they were not essentially heeding the black and white statutes to the letter of the law. And I think that's something you see in common here with the Rodriguez decision. You see the Second District Court of Appeals saying, the appeals board, again, is sidestepping the UR statutes with this case law, which they've come up with. And that's not right. That's basically sidestepping the lawmaker's intent or the legislative intent of when they pass these statutes. So what we've seen in the last 2 months is 2 appellate courts saying, whoa, let's get back to the letter of the law. Let's get back to the labor code. And we're going to more strictly construe or decide cases based on what that labor code says, as opposed to case law, which was created at the appeals board level.
Sure. And that's what all of us are asking for, no matter if you represent the defense or the applicant. Just apply the black letter of the law, right? That's what we're asking for, nothing more, nothing less. But if you apply that, then everyone can live with the results here. Now, before I move on, anything else either of you want to kind of chime in on as far as the implications, where we are, where we might be headed as far as post-Rodriguez, post-Patterson doctrine?
I do have one other thing to mention. One theme you've seen in the blogs this year is lots of talk about the SIBTF, their cost getting way out of control, and the WCRB ringing the warning bell that, hey, the loss ratios are highest they've been in 25 years. And so, in other words, to put it very simply, costs are through the roof. And that's through the roof to the point where Governor Newsom said, in 2026, I've got to address the SIBTF, or else we may not have an SIBTF in the future. And SIBTF is the Subsequent Injuries Benefit Trust Fund. It's California's version of the Second Injury Fund. So, in other words, costs are through the roof. And so when you have cases like this, which are eliminating those additional discovery costs and eliminating that additional switching of the burden of proof, it could mean cost savings. And that could mean maybe slightly less extreme workers' compensation reforms in the future. So if this decision is going to help bring down cost a little bit, that's good, because right now the insurers and defendants of the world have been losing money the last few years. And when that happens, they stop writing in California. And that's what led to Senate Bill 899. And that's what led to Gray Davis being ousted as governor of California 20 years ago. So when we talk about high cost, it's not just me complaining. It's, that has implications that can knock a governor out of office. And so if this decision is going to help lower cost, then that could really impact the reforms that we're expecting in 2026.
Oscar?
Yeah, please.
If I can. Yeah, I think one other possible consequence of this is we might see a push from CAW. Again, if this is upheld and becomes the law of the land, you could see a push from CAW to in the legislature to enact reforms that might mute the success of this litigation. And what I'm getting at essentially is that at oral argument for the first time, both respondents argued that subdivision K or subsection K of 4610 applied somehow to create this exception that they were arguing for. And that subsection K basically says that there is a 12-month pause, if you will, on subsequent UR or RFAs if the treatment in question has been modified or non-certified, meaning that the doctor cannot issue another RFA within a 12-month period for that same treatment, absent a change of circumstances. And maybe that's where the board got this change of circumstances language in Patterson from. But we could see a push from CAW to try and change that in such a way that a 12-month statutory pause applies also not to just utilization review denials or modifications, but to certifications as well. I don't, again, if I could read the tea leaves, I wouldn't be doing comp, but if the chances of that, I think, succeeding probably would be fairly minimal. My 2 cents.
No, that's all we can ask for, our 2 cents. You both have been phenomenal. It's always an ever-changing landscape of workers' comp, but whenever something like this happens, to have you both on is just great for our audience and for our listeners. Louis, you're doing a great job with our appellate division. John, you do phenomenal work with the editorial board. We would love to have you both back on the Comp Corner soon, and thank you both for your time.
Thanks, Nasser.
Yeah, thank you so much for having us. It's a great honor to be on the best workers' comp podcast out there. And yeah, great work, Louis. Thank you, Naz, and wish all of you a great day.
Thank you, sir. For CE credit information, please check out the show notes, which have a link to the CE credit form, or send an email to compcorner@bradfordbarthel.com for the CE credit link. Great job by Louis Larres and John Kamin. And as always, we look forward to you joining us next time on Comp Corner.